open meeting law update from Jennifer McLennan. Thank you for being with us.
Of course, thank you very much.
Thank you for keeping us legal.
No trouble. Legal? Legal, right. So Dr. Boyle asked me to come and speak to you today at your in-service about the open meeting law, and it's entitled Open Meeting Law Update, although I can tell you that really there is nothing to update you on. There haven't been any changes to the open meeting law in recent years. There hasn't been a whole lot of litigation that would have come out of our court system regarding the open meeting law. And there haven't been, most importantly, any Attorney General opinions that have come out regarding interpreting the open meeting law. Generally because there's not a big push at the Attorney General's office to do, to issue opinion letters. So for the new board members, the way that you have a set of laws that apply to you, most of those laws are in Title 15, which you are familiar with many of them. But as a public entity, you also are governed by Title 38. Title 38 governs public entities, and so Title 38 has in it provisions regarding the open meeting law, has provisions regarding conflicts of interest, and it has provisions regarding the public records law. And so what I'm going to talk to you today about is the open meeting law. All of those laws can be interpreted just by looking at the statutes. They can be interpreted if they're challenged in court, but particularly with Arizona school districts, Attorney General opinions, the Attorney General's office can issue opinions if a legislature asks for them or school districts can ask for an opinion. And if they choose to, they can issue public opinions that are become a part of jurisprudence or what you rely upon. Courts don't have to find the same way that the Attorney General's office did, but they generally do. So specifically in the open meeting law, and the materials that I asked Dr. Boyle to distribute to you today are from the Arizona Ombudsman's office. And the reason that I add this is what the front page of it looks like. The reason that I have distributed these materials to you is that when you are accused of violating the open meeting law as a public board, and I'm sure Creighton never will be, but if you are accused, and I've had 2 clients in the last 3 years that have had to enter into conciliation or agreements with the Attorney General's office. And always a part of those agreements are training, so that the boards are required to undergo training. And the materials that the Attorney General's office requires you to use when you're trained on open meeting law are the materials I distributed. So that's why we have these materials. They're very comprehensive. I am not going to go through 67 pages or something. But the fact that we've given them to you and that you have them as a resource should you ever be challenged on the open meeting law, this session would serve as a sort of acknowledgement that you are a board that actively listens and learns about the open meeting law and is actively provided with materials that are relevant to do so. So that's kind of why for the choice of materials. I don't mind if we degenerate into just talking more questions. So if you guys have questions about anything that I'm talking about today, you can stop me at any point in time. So what I want to do, especially because we have 2 new board members on the board, is just kind of go through a little bit about what the open meeting law is, what it requires, and then try to share with you some of the stories that I've taken from other boards, other situations, so that you don't make the same mistakes, I guess. Is that all right? Did you go through any ASBA training when you took your board positions on open? Okay, you did. So, the basics of it, and that's great. ASBA's training is good. I don't know what materials they used or who did it. Do you remember? No. Anyway,
Chris Thomas.
Chris might have done it, but he doesn't too generally with trainings. So the essence of it is that everything, because you're a public entity, everything that you do has to be out in the open. And it's the same for your public records laws. And you all should be aware that your communications, do you all use district email communications, or do you have mostly? Okay. So if you're using your personal communications, you should be aware that if you're conducting board business over those personal email accounts, you are opening up those personal email accounts to being subject to a public records search. If you're using district email accounts, that should not be a problem. But the reason for the openness is basically a sunshine law. It intends that the government of the business should be operated in a way that is open to the public. Any board-appointed committee that you have has to comply with the open meeting law. So if you have specific advisory committees or board-appointed committees, they also have to comply with the open meeting law. Which is why, in some instances, you all and school districts choose just to have committees that are superintendent's committees that are not board appointed, and that's one of the reasons. So if you ever wonder about that, that's one of the reasons. There are exceptions for specific school district events. So for instance, student discipline hearings don't have to be conducted in open session so that everybody can listen. And that's primarily because there are confidentiality concerns with the student disciplinary hearing that you wouldn't want everybody in the public to see.
Would that be in an executive session?
It is an executive session, and it is the only time you can vote in executive session. So I don't know how you structure, and hopefully you don't have very many. Go ahead.
No, the only time we can vote, I'm sorry, can you repeat that again, is?
The only time you can vote in an executive session, even when, I don't know how you do it, but when you adjourn an executive session, you don't take a vote to adjourn it. The board president says, okay, we're leaving now, you know. And the reason is that you may not take any vote in executive session. And we'll go through executive sessions more carefully, but the only exception to that is in a student disciplinary hearing, you can actually take the vote to expel a student or a long-term suspend a student in exec session, because that proceeding is entirely exempt from open meeting law rules.
Because
Now-
you're dealing with a minor? Is that why?
It's because the confidentiality concerns,
Okay.
because the Family Education Rights and Privacy Act applies, so you can't reveal that information to the public. Now, I have a lot of clients that, because they are super cautious, will actually take the action to expel or suspend in the public meeting, but not refer to the child in any way, refer to it by vendor, and I don't know what Creighton does.
We have a hearing officer, who's an
Perfect.
attorney,
Yeah.
and we have a closed session, the report goes to the board, you've always taken it without using.
Okay, and that complies. That system complies. But should there ever be an appeal to the board where you have to hear from the individuals, that appeal session could occur in the executive
And we've
session.
had that happen.
Right. So that would be a common time when you would have executive session. Let me just kind of talk a little bit about, briefly about your notice provisions. You have to have your agenda be specific enough that members of the public can tell what you are looking at or doing, okay? So, and then whether that has to be, whether it's an executive session or a public agenda item. So today, for instance, you know, your agenda item very clearly talked about, you know, that you were looking at different options for the full language immersion program, and that, you know, that's just an example. You have to give enough information. If you're going to be looking at your teacher salary schedule, you have to tell people, yes, we're looking at your teacher salary schedule. If you'll be looking at changing calendar, you have to say that. Looking at changing boundaries, you have to say that. And the notices, there has to be notice that's given to you guys as public officers. There has to be a public notice that's posted of the meeting. It's specified by law where you post that. So there's actual statutory assignment to Creighton as to where you post your public notices. You're supposed to be posting them on the internet. If you have it, or if you have the internet available, have a website, those notices should be up on that. You can't post notice less than 24 hours prior to a meeting. Okay? There's a procedure if you mess up. There's a procedure for ratifying your board action, okay? It's very, very unusual. I've had to use it like once or twice in my career. But there is just know and be aware that if there is a mistake, there is a procedure for ratifying action that you've taken. And why is that? That is because, so for instance, let's say you guys hold a whole meeting and you learn that the notice was never put up, you know? Although I know for sure that wouldn't happen because I know who puts up your notices, and she's sitting to our left and we know how diligent she is. So, but if you learned after the fact that your meeting was invalid because of a violation of the open meeting law, the business that you transacted would also be null and void, because that's if you do something in contravening the open meeting law, the business that you conduct is null and void. And so, you have a process for ratifying that if you need to. Okay, so we talked about agendas, talked about the content of those agendas being specific. And the materials like page 14 on are, the Arizona Attorney General's Office has published an agency handbook that is what the materials are from page 14 through the bulk of where the notices start, okay? And that's probably the first part of the materials is just the law, which is dry. The rest of it gives some good practical advice. One thing I want to talk to you about a little bit is the call to the public. And you all just had a very extensive call to the public, and you ran it very well, Matt. So, yeah, there's
A little more
no,
pressure than the attorneys.
right.
I was hoping if there was anything that was horribly wrong that would get me in trouble, you would.
No, I would, don't worry.
Keep the taser for those.
Right. But the most important part to remember about a call to the public is that you cannot prohibit somebody from speaking based upon the content of what they're saying, okay? So I have been in situations with clients where they have, and all you can do as a public entity is set reasonable time, place, and manner restrictions. So Matt's initial opening statement regarding that they were reducing the time frame from 5 to 3 because the number of cars you'd received is perfectly appropriate if applied to everybody. As it was also appropriate to cut off when one gentleman was having extra time, it was appropriate to say, look, you had your 3 minutes and that's all you get, you know. So that, and the reason for that is because you cannot, as a public entity, discriminate or against what someone is going to say because that's a violation of the First Amendment. So those restrictions on the public comment section not only are governed by the open meeting law concerns, but they're governed by your requirement that you not make content-based judgments on who's saying what. And so that includes allowing them to say things if it's offensive to you as a person, to you, you know. You don't, the way in which I see this most often is when they come in and say rude, horrible things about your staff. That is a really difficult thing to listen to, and I have seen school districts say, well, you cut them off and say that we don't allow critiques of our staff in this setting, and I just looked at them like, oh, well, that's great, I'm glad you guys have gotten away with that for years, but if you got challenged on that, that would be a real concern. So while you can, I definitely say that you can call them out on it and say that your manners, that you're not acting in a professional manner, and you can say all those things, but you can't actually stop them from saying it.
I have a question then.
Yeah.
So if it's an open call, they can talk about anything, it doesn't have to be related to the agenda.
Correct.
Okay. And then, what if they start using offensive language?
If they are using language that is offensive, your board president can say, we don't allow that type of rude behavior in our public comment session. But if they continue to say it, if they make threats, if they are advocating something that's illegal.
So violent threats against a board member,
Right,
or
for
against
sure.
the staff.
Right, those things you can do. If they are just swearing, then what I would do is have the board president address it and say, we don't allow profanity in the public comment
Can the board
period.
member then say, if you continue to speak like this, we'll have to take away your right to speak, or?
You can, and I think that you would probably be fine doing that. So, but what would get you in trouble is if you are taking away someone's ability to speak because you don't like what they're saying, about your staff member, about you, that's what's gonna get you in trouble. Okay, there hasn't ever been any, public comments were added in about 2000, I think, in Arizona, or recodified in 2000 for sure, addressed more, and when the legislation in 2000, what it allowed you to do was to respond to public comments, because it used to be that anybody could come up and say whatever they wanted about a board member, and you couldn't respond to the criticism, and why couldn't you? It was because that item wasn't on the agenda. You know, it wasn't on the agenda for you to talk about why you did or didn't support a district program. So now it makes it clear that you can take basically 3 actions in with respect to the public comment. You can respond to criticism, you can refer the matter to Dr. Boyle for review, or you can ask the governing board president to place the matter on a future agenda item. So those are kind of, if you have something that someone brings to your attention in public comment and you want to do something about it as a board member, those are basically the 3 things you can do by law. So again, you can respond to criticism, refer it to the superintendent for review, or ask that it be put on an agenda. There's a section in the open meeting law that allows you to consider things on an emergency basis. That if it's not on the agenda or without the 24-hour notice, 23 years practicing now, I've never had that come out. So I don't know what would qualify as an emergency basis, but for the most part, those things aren't. That it would be very, very, it would have to be a true dire straits. So If there are changes to the agenda, you have to prepare, if you have a revised agenda, you have to redo it the same way. I don't know how soon ahead of time do you all publish your agenda before board meeting?
The board members receive it on the Thursday, the board meeting's on the Tuesday, and then the public can view it on Board Docs on Friday.
Okay, so like 3 days ahead. So let's say you have a change that comes in on Monday, and there's a change that the administration needs to see to your agenda. You have to receive it, you have to publish it all the same way. So, we'll talk briefly about minutes. The most important thing to remember about minutes, and you don't have to really be overly concerned about this because you all are a board that allows the executive secretary into your executive sessions for the most part. Whenever I've had an executive session in Creighton, the government board secretary's been there, which I think is a great practice. The reason I think it's good practice is because she can be responsible for taking minutes. If there ever is an executive session where you exclude all staff, and you can as a board, one of you has to be responsible for doing the minutes for that executive session and for being responsible that they comply with the law. And it can't just recite, we received legal advice regarding X. You have to specifically say for an executive session what direction you were given to whoever the agent may be, whether that's your attorney or real estate person. So there are certain things that you absolutely have to have. Executive session minutes are confidential. The exception to that is that if you are discussing an employee in executive session, and we'll talk a little bit more about what you have to do if you are going to discuss an employee, that employee is entitled to see the portions of the executive session where he or she was discussed. Okay? And the fact that the executive session minutes are confidential doesn't preclude other entities from seeing them. So for instance, the Attorney General's office has wide open access to your executive session minutes. You can share your executive session minutes with me or with your other legal counsel as you see fit. There's an exception that allows you to share them with entities to review compliance and that kind of thing. And you would be required to give them up to the court if they were for confidential inspection if they were at issue. So, I guess my most important story about minutes and executive sessions, when I was a very young lawyer, I was involved, and I don't know how many of you were in the Valley at the time, but the Glendale Elementary School Board had 4 board members that were actually kicked off the board in the 1990s, late 1990s, and I was a baby lawyer working for the partner who represented the board. And so I was charged with the task of going out, and basically what happened in that school district was that the superintendent at the time, decided that he was going to make a change with respect to personnel. And I will tell you that or if you change your calendar or your vacation schedules or your start and stop times, those are, as you've experienced, those are going to be the kind of high profile issues where you might be accused of violating the open meeting law. Anyone can file an open meeting law complaint. It can be any member of the public, any employee, it can be any of you, it can be any board member. Okay, you can file against each other. I have boards who've done that all the time. If an open meeting law complaint is filed, it is filed with the Attorney General's office in the state of Arizona, and specifically with the open meeting law enforcement team. Okay, so in in Glendale L, they decided that they were going to recommend, the administration recommended the non-renewal of 2 administrators. And one was a principal and one was a district level administrator. The 2 administrators were tied with one of the board members, so it was a split board. 4 of the board members supported the decision to non-renew the 2 administrators, 1 of the board members did not. And the non-renewal decision was made, and the principal was furious, and so he drove around the city taping the board members. And the board members had been socializing at another district superintendent's home. And so they were filmed going in and out of this not their superintendent, but a superintendent of another school district. They were filmed going in and out of this home. And so the young baby lawyer, Jennifer, was required to go interview each of the board members and talk about what they talked about in the home, what they talked about with their socialization, what they were meeting there for. And I guess it was suspect to the public and certainly to Fox News, because there was no one else. It wasn't like there was a party going on in the home. They were just meeting together in their home. And they obviously didn't have any recordings. It got really interesting when the district superintendent's sister, who lived in the home, decided that she was going to testify on against the board members at the Attorney General's office. And when she started to do that, the whole case kind of blew up. And all four, it was the largest penalty that was ever given to board members. All four of the board members were kicked off the board, or required to resign as part of it. They were fined personally. And the fines, open meeting law specifies that if you violate the open meeting law, the fines are personal to you. The district doesn't pay them. Both Dr. Bogner, Dr. Boyle, and myself can be accused of and fined under the open meeting law if we aided and abetted you in violating the open meeting law. And that law was changed as a result of the Glendale case. The Attorney General's office had a very, very proactive prosecutor who was trying to make a name for himself in terms of getting that board disbanded. And when it changed, he also pushed legislation through to make it clear that he thought the superintendent was at fault, without that superintendent was also assisting the board and talking about things off campus. Having interviewed each of them, I can tell you that I don't think that they actually did violate the open meeting law. I just think that what they did was not smart, with good judgment, you know? But there was absolutely no evidence in any of the depositions taken or anything that I studied that could prove one way or the other that they actually sat and talked about it. But the fact that they were all going to a home together, talking with each other, that didn't look good. And so that's one thing for you all to think about as board members, is how much, and that's difficult, you know, because you all are, you are 5 human beings who probably don't have a ton in common other than the reasons for being here. That you work in, you know, like Creighton Element. Obviously, all 4 of you have an interest in education. I know this. Obviously, all 4 of you care about the kids and the community. But often, it's difficult to find topics that, as humans, to talk about other than, well, what do we have next, and what's coming up down the pike, and what do you think about this, and what do you think about that? It's very against human nature to not be able to share with what your one for sure common interest is. Legally, if 2 of you have spoken about a matter, and let's take anything, let's say worst case scenario, you're going to close the school, which is another way in which someone might challenge. So let's say you have to look at closing a school, and 2 of you talk about what your thoughts are. That in and of itself is not a violation of the open meeting law. It also is not something I recommend, because you don't want to put yourself in the light where you can be seen as where you could be accused of violating the open meeting law. So but let's just say that you do, 2 of you talk about it on the phone, let's just say on the phone, and a 3rd board member tries to speak with one of the 2 that spoke about the same issue. Those 2 that spoke should say up front, I have already spoken to this with another board member and I cannot speak with you about it. And that's a perfectly okay thing for any of you to say as board members. And that little sound bite should be a part of your repertoire. And you should really use it. Because if you've already spoken with another board member, to bring a 3rd person into the loop creates a quorum. The idea of a quorum is that there are 5 of you, 3 of you form a board meeting anytime you speak. One of my best examples of this is we had in another client, about maybe 10 years ago now, I had a client that recommended the non-renewal of a Teach for America teacher. And it was based on unprofessional conduct of that teacher. She was a 2nd-year teacher, and it was a hot button topic. And she asked that the non-renewal discussion occur in the public meeting, which an employee can do, and we'll go through that. And so the whole discussion was in the public meeting. There were thousands of public comments about it. It was a race issue because the unprofessional conduct allegation occurred with an African-American student. So the African-American community was out and supported the student and the parents. And the board voted to keep the teacher. And the administration had obviously recommended the non-renewal of the teacher. So we walked out of and I was there trying to maintain order. And we walked out of the meeting, and we were it was like out of a movie. It was 11:30 at night or something ridiculous, and we were under this giant street light, and it was me and 3 of the board members, and they rushed up to me and they said, what are we going to do about the superintendent now? And I just looked at them and I go, we can't talk about that right here, because this violates the open meeting law. We can't talk about what we're going to do with the superintendent or what you all want to do with the superintendent's contract outside of this meeting in public view, So, I mean, it was very high emotions, and it was a very, difficult issue, and their instinct was to try to figure out the next steps. Now that they had not supported the administration, they had obviously, in my mind, come to a decision that they didn't want the superintendent back. And so you have to be, again, really, really cautious about personnel decisions, because those are the ones where you're gonna see challenge. Okay?
I have a question.
Yeah.
Say, so a social event, I mean, we're all going, or I don't know if we're all going, but a lot of us are going to the board, conference, the National Board Conference in San Diego.
I am as well.
And
we're having a
are we
reception
gonna
on
be
Saturday.
accused of, I mean, if we're having dinner together, if we're.
You're fine.
I
Yeah,
post,
right.
I post it.
So after the Glendale L case,
Okay.
school districts started posting social events. And Hilda posts that all of you will, more than a quorum of the board may be present at a social event. And the posting probably says, or it should say, no business actions items will be discussed or taken. So
Okay.
you're fine to be in
Okay,
rooms,
I have mutual friends with some of these guys.
and that's fine, you can talk.
And if they have a party, which has happened, at their house, and say 2 other board members show up,
Safest to post,
but what if we don't know that the other board members?
as long as you're not talking about board business, you're fine. I mean, that, the
But if somebody
violation.
watches,
It's-
films us going into the house, or.
It's not, again, it's not a violation of state law for 3 of you to be in the same room together outside of this room. What it's a violation of state law to do is to talk about a matter that is or could be on an upcoming agenda.
Okay.
That's what you can't do. So you have mutual
Can
friends.
we talk about something? No, we can't talk about something we want on an agenda either.
No,
No. Okay.
right, you're getting it. It's hard. It's really hard, because you don't, it's against your instinct as a person, because that's what you have in common, and you want to further the ball, you want to try to make sure that those are things that your interests and the other person's interests, and you want to know where they stand, all those things, but you can't know where people stand, you can't poll each other, you can't be, you can't try to figure out, Charlotte can't poll you, she can't call each of you and say, I'm thinking about doing X, and what do you think, and she might.
Can or cannot?
Well, she can't do it in a way that Charlotte can definitely discuss issues with you beforehand. So the superintendent can discuss issues with you, but she could never ask you how you're going to vote on something, and she wouldn't, But she can't try to figure out what the vote would be before it happens. So she can have discussions. You can tell her. She may know. And that's not wrong. I mean, anybody may know. I typically, when I'm going into a board meeting, can tell by people's faces how they're going to vote, before they vote. Now, I've been fooled, too, but most of the time, you are going to know what's happening, but not necessarily.
So in the case of a personnel issue, our personnel issues are on consent agenda. Sometimes we will have someone who is being terminated, who feels that it's wrongful, will come and speak during public comments.
Right.
What then rights, does that constitute them asking for their personnel issue to be held in a public forum because they've come up and spoken in detail about what happened?
No.
Okay.
Your agenda is your agenda. So if a personnel, and if it's termination of an individual, it's a termination of a classified employee. In Creighton, your classified employees are at will unless they are term certified. So unless they're probably certain classified, and by classified I mean a non-certificated person. Your employees are at will. So if their recommendation to terminate their employment is made, it is appropriate for that to be on the consent agenda or in the public agenda. A board member, if listening to the concerns, felt like the board should be able, the consent agenda just means that it is approved without discussion. Any board member can ask that any item on the consent agenda be pulled from the consent agenda and discussed, right? And so if an individual comes up and speaks to his termination and one of you feel your heartstrings pulled and want to discuss it with the board before you vote to terminate, you absolutely can. And you can also make the alternative decision and listen to him, which he has the right to do by board policy. He has the right to come and speak to you about a recommendation to terminate, and they can use their public comment time to speak to the issues, and then you can vote without discussion if you choose. There's nothing wrong with either decision.
Thank you.
Are you allowed to, in my one-on-one with Dr. Boyle tonight, if I see that kind of thing on there and my heartstrings are pulled or I want more information, can I get that information beforehand, or is that something that has to be done in a public forum? Do you know what I mean?
I do, and there's two answers to that. One is that Dr. Boyle can provide you all information ahead of time about an action item, and if you don't feel like you have enough information to make a decision, it's appropriate for you to ask the administration to provide you with additional information. And typically, the way I know Charlotte, because I work with Charlotte, how she does it is she's not going to just provide it to you, she's going to provide it to the entirety of the board.
Right.
Okay? But that has a second caveat that is a really important one, which is that you as a board member have really two obligations when information comes to you that you don't know if Char has or not. And that one of those is to tell the administration, this issue has come to me as a board member and you need to be aware of it. And they're really, so for instance, let's say it's a personnel issue that hasn't, or a parent issue. Let's say a parent brings an issue to your attention regarding a program. In my opinion, a responsible board member would make sure that Dr. Boyle knows about that issue rather than trying to investigate it or fix it or, yeah, go ahead.
What if it's an issue that's already up for discussion that a parent contacts you about? For example, I had a parent contact me on Wednesday regarding this meeting that we were having today. So am I obligated to tell Dr. Boyle that that parent met with me, even though it's an issue that we know we're going to be discussing, or are you only talking about new issues or, things that are being brought to light for the first time?
Okay, so let me, really two, if there are new issues brought to light the first time, definitely I think you have an obligation to tell Char, because what the issue with that, and this is kind of outside the open meeting law discussion, but a really important one. When you have notice of an issue, let's say some parent comes to you and says, my child's being sexually harassed at the school, and she's being picked on because the boys are picking on her. You have notice of that as a board member. When that information comes to you, if it hasn't gone to, even if it hasn't gone to Charlotte, you don't know that you would be knowledgeable about it to the extent that legally, because you're a public officer and you were told that information, if you haven't done anything about it, and say a month later, God forbid the girl is raped or something awful happens, you have that legal standard of actual knowledge. And so that's why it's really important to communicate those issues to Dr. Boyle. So that's the first scenario. Second scenario you talked about is you're being contacted by members of the public regarding an issue that's ongoing, like the one you had today. You don't have any legal obligation to tell Char so-and-so called me, but as a courtesy, I think most of my board members that we represent do, because you just want to let Char, everybody's on the same page and then it's open. Char's not going to care that you talked to a board member or that you talked to a member of the public. But it's easiest if that information is shared and then it's open. It's a more open discussion, more open here. If you don't feel like it, you don't have to share the particulars. You should just share that this contact was made. The other issue about that is that from an open meeting law perspective, let's say the parent's calling all of you. Well, if Char knows that the parent is calling all of you, then Char can assist you in not making sure that you're not violating the open meeting law, because that person can be the hub of the wheel. So if that individual, who's not a board member, not a staff member, not a district person, she knows how all of you feel about it because she's asked each of you what you want, to do on a subject, then that person could actually assist you in violating the open meeting law if she's telling you, well, I've heard from Matt and he doesn't support it, and I've heard from Carl and he doesn't support it, but Tiffany does, and so you're the last on board. So you're getting information ahead of the board meeting about how board members may or may not vote, and that could be an open meeting law violation. Does that make sense?
Wait, so one parent, what if she's just calling and not telling you the other board members are doing this? She just says, I want to talk to you about this issue and the way I feel about it.
She can, and you can talk to her about it. But
then she calls Jeannie and says, I want to talk to you about this issue, and then she calls Tiffany and
she can talk to each one of you about it.
But
But if
that's not
she's
violation of the open meeting law.
no, because she's not a public officer. But what would be a violation is if she shared information with you about what the other board members said. So if somebody starts to do that, you need to cut them off and say, and that's the important reason for telling Char.
Okay.
The other just kind of hot button issue right now that, again, isn't exactly directly related to the open meeting law, but it is related to the issues that you're struggling with, which is understanding your role as a board member and how involved you should get in the community issues that come to your attention or that you might actually seek out as a board member. Maybe you're particularly interested in something. The Peoria Unified School District Governing Board just got sued along with their lawyers. Every lawyer was named personally and a bunch of their staff members. And it was over the drowning of the child. I don't know if you remember that year and a half ago. A child drowned in a Peoria pool. 2 teachers were on staff at the time. One of the 2 teachers was fired. And the firing of that teacher has spawned extensive litigation. And a part of the teacher's complaint against the board and the attorneys is that, and specifically against the board, is that one board member, the attorney is alleging that the board violated laws concerning personnel decisions because the board member independently investigated the drowning. The board member, they have evidence that the board member went to the pool to see the site, to understand what happened the day of the drowning. And that independent investigation by the board member is a part of the litigation. And I don't know how that'll turn out. I don't know if going to visit like the site of the accident or whatever would actually cause you to lose your ability to make a decision on the board, but that's what the allegation is. So, for instance, let's not take the FLY program because that was, that's not going to inhibit your position. But let's say you have a situation in which we're recommending a teacher termination, okay? Very difficult issues, and let's just take, let's say that we're serving as your counsel and I'm recommending a statement of charges, that you adopt a statement of charges against a teacher. And eventually, and during the way the teacher termination process works, you adopt a statement of charges and the teacher can ask for a hearing, then the hearing is held, then it comes back to you as a board to make the final decision on whether you accept the hearing officer's recommendations or not. That's typically how it works. So let's say during that process, the teacher who is being terminated calls you directly and asks to talk to you and gives you a lot of information about what is or isn't happening. That independent conversation at some point in time could be held against you, or if you are independently investigating. That's kind of the Peoria situation. If there's evidence that as a board member you didn't receive the same information at the board at the same time, then that's where those charges stem from. So it's in your best interest if it's a situation that's very contentious that you're going to have to make a decision on at the end to say, I need to hear that as a board member. I can't hear that independently from you. I need to be with the entirety of the board to be able to hear that information.
So going along with that, I feel like there was something that teachers are supposed to go through certain channels right before they directly contact the board member. Is that correct?
Yes, they should, and that's another good soundbite to have in your arsenal is to ask the teacher, have you spoken to your building principal about this? Have you spoken, and to redirect them, say, look, you need to go through the right channels before you come to me, and who doesn't want to shortcut the process, I mean, if they know, who doesn't want to shortcut it, especially if they're being reprimanded or they're being disciplined by their building principal, they don't want to talk to that person about it, they want to go around,
So if the teacher in the district has a beef with something that's going on, and just comes right to me and starts talking, then I should tell them, I should shut them up and tell them to.
I mean, your safest course of action, and, I realize that.
My next door neighbor's a teacher.
Sorry. And, I'm not in any way trying to cause a rift between you and your next door neighbor, but your safe course of action is to say to that person, and again, this is against human nature too, because the human nature involves a sharing of communication. That's why you're friends with people, But your safest course of action is if it's about that teacher's personal gripes against the district. If it's about what he or she thinks of the curriculum or what, those are different things. That's one person's opinion. But if it's about their job, you're safest to say, if you have a problem, you need to go follow the chain of command at the district so that it gets resolved in the right way. And it might get resolved well before it hits me as a board member, and you would want it to be resolved at the lowest level. And that would be the best thing for you to say.
So, but a teacher can, or, a teacher or employee of the district can say, I think that this is a problem in our whole district.
Sure.
Just as long as it's not their personal, right, okay.
Right. Or about their child, or about their, if it's something that could come to you as a board member for you to make a decision. Let's say not a teacher, but someone's student is being recommended for expulsion and they want you to hear it out. It's the same concerns.
then we should tell them to come to the board, the whole board meeting.
Yeah, you tell me, you have the option always of coming to speak to the whole board if you choose, but what I would advise you to do is go through the channels of administration. You all are a really well-run school district, you have a great administration. If somebody is in, my experience has been working with your district is that if there's an unfairness issue, it's generally resolved much lower than getting to the board level, so that's your best
So
bet.
if she's talking about Common Core or things that are happening, district-wide, in her opinion of those things, that's okay.
Yeah, I mean, I wouldn't tell you not to talk about that. I wouldn't telegraph your own opinions too much, because you don't, same reason. But for instance, there was a recent case, an Attorney General opinion that said that if Annette decides that you're going to speak to the Arizona Republic on your opinion regarding the teacher evaluation system, well, you're telling the other board members who are speaking to the Arizona Republic what you think about it, right? But that's not a violation of the open meeting law. You have the right as a board member to issue public comment in your capacity as a board member about a certain issue if you wanted to.
By your own personal opinion.
Yeah, about your own personal opinion. But another soundbite is that that's just my opinion, I'm one of five,
Yeah.
So, great questions. So I get, bottom line, the more communication you have with the administration about these issues that are coming to you individually as board members, the more you'll protect the district. Because again, there's a concern about board members investigating them on their own. There's a concern of the same individuals contacting the other board members about an open meeting law break if the communication from one board member is kind of being passed down the telephone chain to other board members. So those are the main two concerns. Okay, executive sessions. You have to vote to go into executive session, and they have to be posted on your agenda. And there's only a few reasons to go into executive session. There's, I think, 7 in total.
You said you have to vote to go into executive session. Is that, you mean when we are at a session that's not already
Correct.
listed as an executive session?
Right, so, yes, good clarification, Matt. So if you're in a public meeting, you have an executive session, let's say it's for, you have one executive session for personnel items, and then you have an executive session to consider your meet and confer obligations or whatnot. You meet with your employee group. You can vote once to go into executive session, and that motion should say we're going into executive session first for this purpose, and then for that purpose, and then you vote to go into executive session, and you don't have to come out and re-vote in between the two.
But when we have something that is noticed as a 5:30 p.m. executive session, and then we as a board have our public meeting at 7 p.m., we don't have to vote to be into that executive session at 5:30.
You typically do, and we have, we typically do.
It's posted as a special meeting.
Right.
Oh.
So we go into a special meeting and then you guys voted to go into
Oh, that's right, we do motion, okay, you're right. It's,
Yeah.
we don't vote to come out of it.
You don't
because
vote
we
to come
can't.
out, that's right.
Correct.
And Creighton was taught by my old mentor that to leave the door open when you're making the votes, because theoretically, until you shut that door, it's an open meeting, even though it's in that boardroom and not this boardroom. So, again, but that's how you do it, the mechanics of it. The reasons for it, one is, and the most often used is for personnel matters. So let's say it's time to talk about Dr. Boyle's contract, and we can talk about her contract and her job duties and her assignments and her personnel pay in executive session, and that's probably the only time I've been out to your board recently, which is great. But when that happens, Dr. Boyle actually has to receive a notice from NYMEC Sugarhill Sensitive that says she's going to be the subject of an executive session. Because if you're going to talk about any person who's a staff member of the district in executive session, whether you're talking about that person by name or by position, they are entitled to notice, and they are entitled to a notice that allows them to have the discussion in the public session if you want. And that is another thing that is very difficult. So let's say you're talking about a real estate option, and as the issues come up when you're talking about the real estate option, you are worrying about what's going to happen to the principal at the location of the school, and you ask what's going to happen to the principal, and you guys start going off on a tangent about the principal, the staff connection to the issue you're discussing. You can't do that. So that's, or a meet and confer. You're talking about meet and confer and different issues with different teachers, and then you start talking more specifically about those individuals. You can't single out any individual staff member to discuss an executive session if they haven't received notice prior. questions about that? You can talk about records that are confidential. So if there are, most often that's used for the student disciplinary hearing issue, but if there's going to be a discussion of, let's say you're talking about a personnel action and most of the action is going to be talked about in the public session, but there's one particular issue that you have to talk about that is HIPAA protected or has a privacy concern. You could talk about that confidential information in an executive session. I guess the second best used executive session is for legal advice. You can get legal advice during executive session. There has to be a lawyer present. So that's an important factor. I have had a governing board who was sanctioned because their lawyer, it wasn't me, didn't show up to their executive session, and one of the board members happened to also have a law degree, and so she took it upon herself to conduct the legal executive session and give legal advice to her co-board members as an attorney. And she was not the attorney for the public body, and so they got sanctioned for allowing her to proceed like that. So you sometimes, and probably won't happen very often, but sometimes you will get legal advice from me about not having an executive session. Most commonly, if you all, and I hope you don't, ever have to move to non-renew an administrative employee. Let's say you've decided that you want to make a change in your district and Dr. Boyle's recommending the non-renewal of an administrator. It's been my legal advice that you shouldn't have an executive session before that non-renewal. You absolutely can. It's legal to do so, but it causes you, when you are choosing to non-renew an administrative employee, your administrators are at will from year to year. So if you're making that decision, there doesn't have to be a reason for why you are recommending the non-renewal, and the discussion of potential reasons or whether you should or shouldn't have that employee back is generally thought to not put the district in the best light. So there may be reasons why you have a personnel action item that you think, why aren't we discussing this in private? But there may be actual legal reasons for you not to be, for the action to be taken in an open session and just have the action taken. Okay? And that's the best example of one, or the one that would surprise most board members, where you would think that you would be able to talk about that behind closed doors. We had I had a teacher termination matter this last month, and I'm going to pick on another client for a minute, and we had a board member who, unfortunately, she's been a board member for a long time, so she should have known better. When you have a teacher termination hearing, I was representing the administration, and typically, I can represent both the board and the administration, because you are all one entity. You are all the Creighton School District. But in the situation where you have a hearing, the same lawyer cannot represent the board and represent the administration. So that would include student disciplinary hearings, whistleblower hearings, and a teacher termination hearing. So because I was representing the district administration, I asked another attorney, I didn't hire her, the board did, but asked another attorney to come in and represent the board. And that attorney met with the governing board president and went through the reasons. There were 2 executive sessions listed. One for the personnel item, considering the firing of the teacher, and one to get legal advice about the teacher termination process, both legally noticed. The teacher asked for the hearing to be held in public. That's her right. So she submitted notice the hearing was held in public. The board was still allowed to move into executive session to get the legal advice. And so the board made a motion to move into executive session to get the legal advice. And the board member, when the individual representing the teacher stood up out of the public audience and said, "Hey, we asked for this to be in a public setting." And the board president, despite being told exactly what the purpose was, said to the individual, she said, "Now I'll take this," because the lawyer had started to answer. And my hair on the back of my neck stood up, oh God. And she said, "I just want you to know that the reason that we're going into executive session is because we haven't had a chance to talk about this among ourselves." And I thought, oh God. Because they weren't allowed to talk about that among themselves. They only were allowed to get legal advice. Okay? And so the board attorney looked at me, her eyes got huge, and they went back into their, and what I did to try to correct it was to go tell the representative, actually, they can only talk about legal advice back there. They can't talk about the hearing as the substantive nature of the hearing. But that also frankly, that night it was easier to be the attorney for the administration and not the attorney for the board, because they're all back in executive session. All they can do is ask legal questions and get legal answers. They can't talk about whether they should or shouldn't fire the teacher, which nobody wants to talk about whether you should or shouldn't fire the teacher in front of the teacher, in front of the whole, God and country and the rest of the board. It was a packed boardroom. So, also against human nature, also not in compliance with the open meeting law. The discussion had to be held in public because the employee requested it. So, and that was my war story for 2 weeks ago. So, you can have an executive session if you have contract negotiations or settlement discussions or litigation. There was a case that came out about 8 years ago, out of Tempe, where they fired a teacher, the teacher appealed, and they voted in executive session, to which at the time they directed the attorney in executive session to file an appeal. So to spend public money to file an appeal. And everyone had thought that because that was a part of litigation, because that was a part of your ability to get information about whether you should or shouldn't file an appeal, can be talked in executive session, but they actually told the attorney, we want you to file the appeal. And that action was brought up on court review, and the court said, no, you can't make that decision in executive session. So sometimes you will see action items on your agendas that are after an executive session, where you are kind of ratifying, for lack of a better word, consensus that was reached in executive session. Okay? And so there will many be times where you have discussion that's in executive session where, there isn't any finality to it, right? You just all are talking about what you want to see happen, and then you may come out and give direction to the attorney for the public body, a real estate representative, your superintendent, give direction about what you want to have happen based upon that discussion, and that's the safest way to avoid that problem or that issue. So you can have interstate tribal negotiations in executive session. You can purchase real estate and talk about that in executive session. There's a case called Tanca Verde that came out that is specifically on point there, where they selected the site of the real estate that they wanted to pursue in executive session, and that was found to be illegal. Okay, how about telephone conferences? Do you guys ever call in? Do you board members call in and participate by phone?
I have not had that happen, but I know we have talked about that being an option.
Yeah,
For executive or for the
Either.
public meeting?
either you can, if you can't be at a board meeting and you want to participate, you have the capacity, you can have someone on the phone. It's awfully difficult, but you can. So,
If they have a personal bobblehead, you can put it right there next to the phone.
Well, no, the bobblehead is here. I've seen it happen at meetings.
Sorry, it was a,
IEP meetings.
so yes,
one of our governing board members has a bobblehead of himself.
that's perfect. And then-
Okay, never mind, anyway.
well, any bobblehead can be, as long as the bobblehead can vote yes or no, I suppose that's just fine.
As long as the bobblehead can get elected.
All right, there you go. You can participate by telephone, but it has to be noticed on the agenda. So that's one important part, that the board members may participate telephonically. So if you think that you have an upcoming board meeting, you want to be a part of the discussion, you can't be here in person, you can transact the business by telephone. Okay,
So you have to know in advance.
no in advance.
Okay. So
Because it has to be on the agenda.
Okay, so I couldn't have last Tuesday.
If it wasn't on the agenda, that you might appeal telephonically if you couldn't have participated. So, let's talk about emails, big issue. Your emails are not only public records, but they are the best evidence that you're violating the open meeting law if you're violating the open meeting law. So you have on your, the bottom of your emails that are sent from your administration, you have kind of like a warning thing that by now you probably ignore or don't see anymore, that automatically goes out, that says, don't transmit this to other board members, and don't respond back or hit reply all. Because if you hit reply all, you are violating the open meeting law because you are communicating about a board action item by email, okay? The Yavapai Community College there was a open meeting law complaint, and the Yavapai Community College board members were all individually fined, and it was all based on their email communications. They were having discussion about agenda items, they were asking about, feelings about agenda items by email. They were specifically directing people to put agenda items on, which we thought was fine because it was a unilateral communication, but the AG's office found that to be in violation. So there's a blurb in here about that, but just be really, really cautious about your emails. Be really, really cautious about not sharing your emails. Let's say you get a parent that, a parent that emails all of you about a board issue. If you hit reply all to that parent, even though you might want to share what your response is to that parent, that could be a violation of the open meeting law. Okay? Any questions about that? Okay, sanctions, we kind of went through that. We talked about the 2000 changes that were based on the Glendale Elementary investigation. They can civilly sanction you. They can require you to pay attorney's fees to a plaintiff. They can eventually remove you from office. And the sanction is per violation. So I think it's $2,500 per violation. So, and that concludes my
I
lecture.
wanted to know, all these fees in Glendale that they got and all that, how much were they?
I think that they knocked down the fees because they resigned. So my recollection is that they did not have a great deal of personal fees. The Yavapai Community Board members ended up paying, I think, $2,500 each out of their own pockets for the email violations that I was talking about.
Did they go to jail if they don't have the money?
There's not, yeah, I don't know, that's a good question. So it's a very unusual remedy, very unusual. We were talking about the non-renewal situation, so let's kind of, this is a kind of example. Had a rural school district that moved to non-renew one of their principals, and I told them exactly how to do that, wrote the agenda item for them, and without asking me or informing me, they also, in addition to my agenda item, put an executive session on to discuss the item on their board meeting, and then they ended up voting an executive session to non-renew. So they violated the open meeting law by voting an executive session, and it was clear cut that they had. And so the disgruntled former principal filed an open meeting law complaint and a lawsuit, and so we entered into a resolution with the Attorney General's office, and the Attorney General's office said this is a first-time violation for this district, and we're not going to fine them. But if you have repeat violations, then they fine. So they give you a free bite of the apple. They make you do training like we're doing now. That's kind of why we're doing this ahead of time, before, God forbid that you ever be subjected to an open meeting law complaint investigation. But if you are, it will be beneficial to the investigating body that you all had open meeting law training. So anyway, my point is, it's very unusual to
Okay.
fine. And most of the time, what the Attorney General's office will do is order training.
Thank you.
No problem.
Questions?
So if we violate the open meeting law and it's in this packet you gave us, and they say, well, you need to do the training, and you say, oh, I already gave them the training.
They'll make me retrain you.
Oh, okay.
They make you retrain you. But what the reason I believe that Dr. Boyle's had me do this, I think I've done this twice, because I know I trained Tiffany when you came on the board. When was that? Yeah. Yeah, the first time. Yeah, we had it. I remember the first time. Yeah. So anyway, the reason that Dr. Boyle schedules training, especially if there are new board members, is so that we can say if there is an investigation that was concluded, and then they will go more lightly on you. There's not going to be any issues. You guys aren't going to have any issues. You understand your rules and obligations. So, thanks. I enjoy representing your district. I am so happy about your academic success and the success you're having in different places. It's really wonderful to see. So, really happy for you. Happy to have new blood on the board. It'll be fun for you all to work together. So, thank you very much for letting me serve as your counsel.
Thank you.
Thank you.
And because my understanding of open meeting law is we can't discuss an item before the time period at which it is noticed, so
Sorry, I got you on really early.
we will, no, that's okay. So we'll now go home and take a nap. We are in recess now until 2:45. Our next agenda item is, will begin at that time.
And I'm
Oh.
sorry, I have to go home and sleep.
Okay, that's fine.
I'm sick. I'm sorry, I can't see. Maybe they'll
Not a
tape it now.
problem.
Watch.
That's right. Once you have the tape, right?